Okay, let's begin. I appreciate everyone coming here first thing in the morning. Good morning. I'm Tom Fitton. I'm president of Judicial Watch. Judicial Watch is a conservative, nonpartisan educational foundation dedicated to promoting transparency, accountability, and integrity in government, politics, and the law. Through its educational endeavors, Judicial Watch advocates high standards of ethics and morality in our nation's public life and seeks to ensure that political and judicial officials do not abuse the powers entrusted to them by the American people. Judicial Watch does not endorse or oppose candidates for public office. You know, the rule of law is the foundation of our constitutional republic and ensures that we are, as Founding Father John Adams would say, a government of laws, not of men. The rule of law dictates, among other things, that the law applies equally to the rulers and the ruled, the rich and the poor, and the bureaucrat and the taxpayer. Unfortunately, the concept that no one is above the law seems increasingly alien to too many elected officials, and in particular to too many appointees of this administration. I'm convinced that the disconnect most Americans feel from Washington comes from their belief that in Washington the rule of law is increasingly irrelevant to the operations of the federal government. Americans see bailouts with the barest legal justifications and the exercise of raw executive power to take over private companies. They see laws such as Obamacare passed in mockery of the long-standing rules and procedures of both houses of Congress, and then they see this administration waive this very law for millions while forcing the rest of America to follow its rules and bear its costs. Americans know that there are laws against illegal immigration, yet they see the federal government simply refusing to enforce these laws. Even worse, they see a presidential administration that has made the startling decision to grant, in effect, amnesty to potentially millions of illegal aliens through executive fiat. And they see an administration that, while professing to want to shut down gun trafficking, that actually ran a taxpayer-funded program that trafficked in thousands of guns to Mexican drug cartels. We owe a lot of thanks to our special guest here today for bringing that last scandal, known as Fast and Furious, to light. When a federal law enforcement agent on the southwest border was killed on the job, Senator Chuck Grassley demanded information and accountability from the Bureau of Tobacco, Alcohol, Firearms, and Explosives, otherwise known as ATF, about its high-risk program, which allowed guns into the hands of the illegal aliens shooting at our agents. I am honored that Senator Chuck Grassley is here today to talk about some of the topics, in addition to Fast and Furious, in further detail. The title of the talk is The Rule of Law Under Attack, from Stealth Amnesty to the Fast and Furious scandal. Judicial Watch has long admired and is thankful for Senator Grassley's work on behalf of government whistleblowers, some of whom have been Judicial Watch clients. First elected to the Senate in 1980, Senator Grassley has earned a reputation in Washington for standing up for common sense and holding government accountable. Chuck Grassley does his job with a work ethic that can be traced to the Butler County farm, where he grew up and still lives today, and to his days as a young father of 5 who worked 3 jobs. Senator Grassley serves as ranking member of the Senate Committee on the Judiciary, where he works for a competitive marketplace with antitrust enforcement and tort reform to reward innovation and invention with an updated patent system and for legal immigration that will help America's economy grow. Grassley has led a campaign to open up the federal judiciary by allowing cameras in the courtroom, and as I said, he is unmatched in his legislative and oversight work to protect whistleblowers, both in and out of government, and who speak up also about wrongdoing for the public good. Whistleblower laws authored by Senator Grassley are the federal government's #1 anti-fraud tool. Senator Grassley commits tremendous time and energy to congressional oversight. He works to shed light on the federal bureaucracy. He champions transparency when it comes to the people's business. Chuck Grassley's time-tested blend of pragmatism and integrity gives him a license simply to tell it like it is, and telling it like it is in Washington is music to Judicial Watch's ears. So without further ado, let me introduce Senator Grassley, who will make a presentation, and I will open it up for questions and comments, and hopefully get him out here on time to his other important business. Thank you.
Thank you.
Thank you, Senator Grassley.
Thank you. Thank you, Tom. You did a very good job of laying out the issues that I'm going to be addressing, and also the issues that you've assigned to me, but those are issues that I feel very comfortable in discussing. In fact, almost every day I have something to do with each of these issues. So thank you very much for your kind introduction. And I appreciate the opportunity this morning because Judicial Watch is well known for its advocacy of transparency and accountability in federal government. And as you can tell from my introduction, those are things that I'm very interested in. But contrary-wise, our federal government is well known for its silence and its ability to circle the wagons and, of course, to protect its own. That's kind of the culture, not only of a particular presidency, but it might be the culture of all bureaucracies, regardless of who's president. Because I've seen this time and time again when I've uncovered embarrassing information within the executive branch. I've been conducting oversight of the executive branch since I first came to the Senate. Now, of course, it's history, but you might remember my first major oversight, $435 hammers, $750 toilet seats in the 1980, and DOD. Oversight is a critical function and, of course, a constitutional responsibility of the legislative branch. And, in fact, it's often an overlooked function for members of Congress because it is not glamorous and it is a lot of hard work. Some people have said recently that my oversight work is political. Obviously, I take offense to that because, quite honestly, people who say that are the ones that I think are really trying to be political or divert attention from the real issues that I bring up. Because I consider myself an equal opportunity overseer. I don't care if it's a Democrat or a Republican occupying the White House. In 2008, I was glad to hear the president-elect talk about the most transparent government ever that he was going to institute. Unfortunately, up to this point, this administration has been far from transparent. If any of us thought it was bad before, it's worse now. In the two topics that I've been asked to talk about this morning, it's clear that for the current administration, the rule of law is more about perception than reality. They've circled the wagon, made denials, and generally been non-responsive to a member of the Congress's legitimate inquiries and constitutionally proper inquiries. Amnesty happens to be one of the issues that I've been asking tough questions about. Since the founding of our country, our immigration laws have been a source of discussion. We were born a nation of immigrants. We have welcomed men and women of diverse countries and provided protection to many who flee from persecution. We have been a generous nation. Yet, we have seen our country face many challenges and have attempted to restrict immigration levels. The first immigration law of 1790 tried to limit citizenship in certain individuals and instituted what was then called only taking people of good moral character as citizens. We created quotas in the 1920s to only do away with those quotas 45 years later. We even provided amnesty to millions of undocumented and hardworking people in 1986. Today, we're faced with another challenge of how to deal with more than 10 million undocumented persons. Congress struggles with this challenge on a yearly basis. During this struggle, it is important for lawmakers to bear in mind that the policies we make should benefit our country over the long term, and that we must be very fair to current and future generations. People in foreign lands yearn to be free. They go to great lengths to be a part of the United States. It's a privilege that people love our country and want to become Americans. At the same time, however, we must not forget one great principle that our country was founded on. That is the rule of law. We want to welcome new Americans, but we need to live by the rules that we've set. We cannot let our welcome mat be trampled on, and we cannot allow our system of laws to be undermined. As a United States Senator, and for that matter all senators, I and we took an oath to honor the Constitution. I bear a fundamental allegiance to uphold the rule of law. That is why I'm deeply concerned about the immigration policies that are emanating with this White House. The Obama policies may be an impermissible intrusion on Congress's plenary authority over immigration law. They're pushing the envelope for sure, and there's little transparency in their actions. As many of you know, last summer I exposed an internal Homeland Security memo that outlined ways that President Obama could circumvent Congress and grant legal status to millions of undocumented individuals. This memo was titled, quote, Administrative Alternatives to Comprehensive Immigration Reform, end of quote. Now that's both a political statement as well as a blatant effort to get around law. Its purpose was, in their words, quote, to reduce the threat of removal of certain individuals present in the United States without authorization. Now there's a lot of truth in that statement, but also an indication of how do you get around the law, or how do you get around Congress's inaction. The memo outlined more than a dozen ways to keep individuals in the country and to provide them with benefits or protections. I, along with my colleagues in the Congress, have asked repeatedly for assurances that these options were not being explored, but our concerns have not been eased. The President and Secretary of Homeland Security have only said that they don't plan to provide such benefits to the entire population of undocumented individuals. They claim that they'll use their discretionary authority and pursue relief on a limited case-by-case basis. Now, in fact, if it were limited, and if it were on a case-by-case basis, there might be some leeway within the law that's intended by Congress for certain instances that we can't predict. But you'll find that this is not the way it's being carried out. Yet, we obviously don't believe what they say that is true. We have no idea how many people are receiving the benefits, are being spared deportation, and being given work authorizations. When prodded, the Secretary finally relented and shared some general statistics with me. And this is very telling. In calendar year 2010, her department granted 34,448 paroles and deferred actions, far more than those granted in the previous 5 years. Despite receiving these numbers, we have not been told how the department processed these cases and what standards were used. In other words, we do not know whether or not the law has been followed. Again, the title of this, the Administrative Alternatives to Comprehensive Immigration Reform, that memo from last summer also included a provision to lessen, quote unquote, extreme hardship standard. Under current law, aliens are inadmissible for 3 to 10 years, 3 or 10 years, if they have been unlawfully present in the United States for 180 days or 1 year, respectively. The Department has discretion to waive the grounds of inadmissibility if it would result in extreme hardship. The amnesty memo states, quote, to increase the number of individuals applying for waiver and improve their chances of receiving them, Citizenship and Immigration Services could issue guidance or a regulation specifying a lower evidentiary standard for extreme hardship, end of quote. Proponents argue that this is needed for family unity and that the 3 and 10-year bar is overly burdensome. There is chatter within the department to move forward with this option that was laid out in the amnesty memo. If the standard is lessened, untold numbers of undocumented individuals will be able to bypass the 3-year and the 10-year bars that are clearly laid out in the Immigration and Nationality Act. My concern is that this policy, if implemented, is a blatant way to circumvent Congress and the law to keep as many illegal aliens in the United States. It is difficult to ascertain if this change is being considered by the Secretary, but it's clear, at the very least, that people within the agency are thinking creatively to make this change a reality. Now, a year after the 2010 amnesty memo circulated, we learned that the head of Immigration and Customs Service, or ICE as it's referred to, the agency responsible for enforcing the law, apprehending and deporting undocumented people in this country, directed his agents to use quote-unquote prosecutorial discretion on those with whom they may come in contact. In June of this year, Assistant Secretary Morton released a memo directing ICE officers to exercise prosecutorial discretion to consider the alien's length of presence in the United States, the circumstances of the alien's arrival in the United States, particularly if the alien came as a young child, the alien's criminal history, age, service in the military, and lastly, pursuit of education in the United States. Pretty broad discretion that the Secretary has given, right? On August the 19th, 2011, Secretary of Homeland Security announced an initiative to establish a working group to sort through an untold number of cases currently pending before the immigration and federal courts to determine if they can be, quote unquote, administratively closed. There are more than 300,000 cases pending before the Executive Office of Immigration Review and more than 500,000 individuals who have been ordered removed that may be considered for relief under this process of administratively closing certain cases. The Secretary, however, claims that this process will allow them to direct resources at higher priority cases. This memo and initiative outlined by the Secretary are alarming, especially to those of us who have said that our country is based on the rule of law. These policies seem to contradict that very important philosophical basis for this country's way of maintaining a society that's not in chaos. On September the 26th, I led 18 of my Senate colleagues in sending a letter to the President expressing dissatisfaction with these prosecutorial discretion policies. We said that the administration was encouraging undocumented aliens to come forth in the hope of relief. We asked the President to rescind the June memo and end the initiative outlined in August, and requested that he make the Secretary available to all members of the Senate to explain how his policies, his immigration policies, are consistent with the rule of law. The President asked a bureaucrat from the department to respond to us on his behalf. The letter, which arrived just yesterday, didn't address any of the points that we made in our letter. Now, that's not a surprise, because that happens quite often. But it also shows complete disregard for the concerns that we raised. So we have many unanswered questions from this administration about their prosecutorial discretion initiative. For example, how many cases will the working group sort through? What standards will be used for adjusting cases? Will those with criminal convictions be eliminated from consideration for discretion? How much in taxpayer money will be expended for this effort? And when will the working group finish its work? Will the Homeland Security Department keep the committee apprised and provide detailed information on who is granted a benefit, including work authorizations? What will happen to individuals who have their cases, quote unquote, administratively closed? Now, we await answers and can only hope that they'll be more transparent with these policies than they have with the amnesty memo. In other words, will this president, as he announced on his first day of inauguration, have the most transparent administration ever? It's unfortunate that they are less than forthcoming about the details of their immigration policies. The future of our country hinges, in part, on the policies that they are making behind our backs. Congress has a role to play. The Constitution says so. The Secretary of Homeland Security plans to appear before the Judiciary Committee tomorrow. It will be our chance to conduct oversight over her department and their policies. And you can be sure that prosecutorial discretion will come up. I also plan, again, to express my concern with how this administration is enforcing the laws and whether they're trying to find creative ways to keep as many illegal people in this country. The president promised transparency, and it seems we struggle every day to get answers for the American people. We need more sunshine in Washington on amnesty and numerous other issues, including one of my oversight investigations that involves federal law enforcement operations that went critically wrong. Fast and Furious was a multi-agency effort run by federal prosecutors in Arizona and supervised by officials in the Justice Department headquarters here in Main Justice. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, or ATF, encouraged U.S. gun dealers to keep selling to people known to be transferring weapons to third parties. These buyers are called straw purchasers, and there were lots of reasons for gun dealers to be suspicious. The straw buyers were purchasing the kind of assault rifles preferred by the Mexican drug cartels. They repeatedly bought dozens of weapons at a time and then returned just days or weeks later to buy dozens more. They paid with paper bags full of tens of thousands of dollars in cash and bought very expensive, high-powered 50 caliber sniper rifles. All of this was plenty of cause for the dealers to report the sales to ATF as suspicious and stop making the sales in the future. But the ATF had even more reasons to be suspicious than the gun dealers had. The Drug Enforcement Agency, DEA, had tipped off the ATF about the activities of the ringleaders using information from a wiretap in a related drug trafficking case. The ATF knew that some of the straw buyers were on food stamps or unemployed, so a legitimate explanation for all the cash that was being thrown around was unlikely. Most importantly, the ATF knew that the straw buyers' guns ended up at crime scenes in Mexico just days or weeks after being bought here in the United States. ATF knew all of this information from the beginning of investigation in late 2009. As early as January 2010, the DEA wiretap had even collected detailed information about who the ringleader was selling guns to, and that information was available to ATF. Yet our government allowed the ring of straw buyers to grow and operate freely for about a year. Starting in late 2009, agents who later blew the whistle on the mishandling of the case were ordered to merely just sit there and watch and record what the straw buyers were doing. The agents were not allowed to stop the straw buyers or even to question them. The agents were not even allowed to continue following the guns once they were transferred to unknown third parties or stash houses. Surveillance was simply abandoned. These details were apparently not provided to gun dealers, even though they cooperated with ATF from the very beginning. The government installed hidden cameras in at least one store, and dealers notified ATF each time one of the straw buyers came in for another purchase. In March of 2010, the ATF had gathered evidence that the intent of the straw buyers was to transfer these weapons to criminals and Mexican drug cartels. The ATF applied for wiretap authority and supplied all the necessary details to Justice Department headquarters in Washington, D.C. Yet, it was not until December 15, 2010, that a single one of straw buyers was arrested. And that was the very same day U.S. Border Patrol agent Brian Terry was killed. Two of the weapons bought right under the ATF's nose nearly a year earlier turned up at this murder scene. Within a day, the straw buyers of those two guns was finally arrested. The other straw buyers were indicted a few weeks later, January this year. ATF agents who knew the ugly truth blew the whistle. The whistleblowers made sure that Congress and the Terry family were fully informed. At first, the department explicitly denied the allegations in writing, and officials implied it was all hogwash in a widely attended briefing for Senate Judiciary Committee staff. By then, the evidence started coming out, document by document, and witness by witness. The truth became so clear that it was no longer deniable. An internal briefing paper explicitly said that the strategy of the case was to, quote, allow the transfer of firearms to continue to take place, end of quote. Emails prove that a gun dealer had prophetically worried that the operation could lead to the death of a Border Patrol agent, and it did. But ATF and DOJ officials reassured the dealers that cooperation was still necessary. They falsely accused the dealers that there were secret methods of stopping the guns before they went south. The House Oversight Committee issued subpoenas and held 2 hearings. My staff worked with them on 2 staff reports detailing testimony and the documents that we have gathered. The Justice Department stepped in and tried to control the flow of information, but we continue to receive documents and information from confidential sources. The Justice Department provided documents from ATF files, but so far they provided very few of their own files from the Department of Justice. To its credit, though, the Department did recently release a very small batch of documents. It included several memos to Attorney General Holder that appear to contradict his earlier claim that he had never heard of Fast and Furious until sometime April this year. The documents also show that Attorney General Holder, currently Chief of Staff, received a detailed briefing in March of 2010. That person was the acting Deputy Attorney General at the time, the number 2 person in the department. The Deputy Attorney General even took detailed handwritten notes on presentation. However, Attorney General Holder says that he didn't know anything about it until after the controversy became public. I know he was at least aware of the whistleblower allegations on January 31st when he came to my office for another reason, and I personally handed him 2 letters about the issue in my office on that day, as for exactly what else he knew and when his statements will have to be tested against the rest of the evidence that we continue to investigate. Included in the documents released recently were emails between senior Justice Department officials that explicitly talked about gun walking as early as October 2010. Gun walking is a term that whistleblowers use for sitting and not stopping guns that could have been stopped. These senior Justice Department officials were discussing whether the head of their criminal division should attend an upcoming news conference on Fast and Furious and another case from a previous administration. Their concern was how, their words, tricky the press conference could be because the guns that were walked. So they clearly anticipated the controversy even 2 months before Agent Terry was murdered and before the whistleblowers told Congress about it. This makes the initial false denials even more outrageous. Some have seized on the reference to a case from a previous administration to suggest that gun walking was nothing new and that our investigation is partisan. So let me be clear. There is nothing partisan about my desire to get to the bottom of Fast and Furious. My motivation is to make sure nothing like this ever happens again and get the truth for the Terry family, as well as untold number of Mexican citizens who may be victims as well. During my testimony before the House committee, I asked the members to put politics aside and just listen to the Terry family and to the whistleblowers that they testified that day. But some people see everything through the lens of their own politics. Rather than listen to the evidence, they wanted to blame the Second Amendment for Agent Terry's death. Whoever pulled the trigger is to blame. That is the person who should be brought to justice. The straw buyers who illegally bought the guns and government officials who stood by and watched them do it all need to be held accountable. So that's the story of Fast and Furious so far. But what does it tell you about the rule of law in America? When we talk about the rule of law, we usually are referring to the idea that government should make decisions consistently. Those decisions should be based on some neutral principle rather than someone's personal whim or bias. And those decisions should apply to everyone equally without allowing a lot of discretion of government officials to pursue their own agendas. In short, we should be ruled by laws and not men. Our government gets its authority from the consent of the government, or governed. Representatives elected by the people write the laws and the executive branch enforces them. However, over years, our government has grown so big and so complex that it's hard to hold government officials accountable for how they apply the law. Fast and furious, it has taken us months to sort out responsibility because of this problem. There are dozens of bureaucrats pointing fingers and shifting blame. There are dozens of lawyers parsing words and shuffling paper. At the end of the day, what we know is that several people in government decided not to enforce the law. These officials believe it was within their discretion to allow straw purchasers to operate despite all the evidence that they were breaking the law. In most other field offices, obvious straw buyers were stopped, questioned, and arrested, but not in Phoenix, Arizona. As one of the whistleblowers put it, Operation Fast and Furious represented, quote, a colossal failure of leadership, unquote, at every level that he was aware of. Just what each official knew at each level in each agency is something that needs to be cleared before our investigation is complete. For the rule of law to function properly, there needs to be supervision, accountability, and consistency. Government officials must know that their discretion to play around in the gray areas of the law has limits. It is the job of elected leaders to enforce those limits on behalf of the people who elected them. But there are so many officials and so many decisions that accountability is hard to impose. The President himself recognized this in the context of Fast and Furious back March of this year, when he was first asked about Fast and Furious on Spanish language television. He was pressed about how he could not have known about Fast and Furious. He responded, quote, "This is a pretty big government, the United States government. I've got lots of moving parts," end of quote. Exactly. That's the problem. Government needs to be limited. It needs to be focused and constrained by the rule of law.
Thank you, Senator, for that presentation. We just have really a few minutes for questions, but I'd like your response to the issue of the Obamacare waivers, the ending of the Class Act for practical purposes, and it doesn't seem the rules are working appropriately in the context of this massive reorganization of our healthcare system. Could you have any comment?
Well, we ought to be glad that there's recognition that there's, even by the administration, that there's some things in this bill, and from my point of view, a lot of things that are not very good policy, and Class Act is one of them. Or the class part of it is one of them. That's the long-term care insurance thing. And even back when we were debating it 2 years ago, the chairman of the Budget Committee, Democrat chairman of the Budget Committee, Conrad, said that it was a Ponzi scheme. And now they're realizing that it can't be, and they don't want to take it out, because if they take it out, it makes their thing less budget neutral, and it's not really budget neutral anyway, but in their definition of budget neutral, it's budget neutral, so if they take it out, it makes it less that way. But they know it's not administrable, so they're doing what they can under their existing authority to waylay it and delay it from year to year, but it's still, it'll have to be repealed if it's really out. From the standpoint of the rest of it, there's 1,693 delegations of authority in the Obamacare legislation to write regulations. So there's a massive delegation of authority, constitutional or otherwise. There's still a massive delegation of authority. And some of it probably is a non-constitutional delegation of authority. But the most important thing is, does it violate the Commerce Clause by forcing people to buy insurance? And I think it does, and hopefully the courts will declare it unconstitutional. And the whole bill unconstitutional, not just that part of it, because it doesn't have a severability clause.
We have time for one or two questions. Yes, up front here. And could you identify yourself as well?
Yes, my name is Gregorio Meraz. I'm a reporter for Televisa News Network from Mexico. We do understand that previous to Fast and Furious, there were some other operations, similar operations. One of them, I understand, was involving also hand grenades for the Mexican cartels. Can you tell us what do you know about this, and why this administration did not learn the mistakes of these previous operations?
Well, I think if I'm wrong on some of these facts, I would stand corrected, because I spent most of my time on Fast and Furious, but I think there's an extreme difference between what you proposed happening before Fast and Furious and Fast and Furious. One would be the total amount of armaments that crossed the border or were sold to straw people, whether they crossed the border or not. A second one was a limited number of guns that were previously sold were actually tracked, and there was a great deal of cooperation between this administration and the administration and law enforcement on the south of the border. And then the other thing is, with these is a massive amount of guns, and they were not followed across the border. In fact, there were times when one of the whistleblowers even told us he was watching a storehouse and called headquarters and said, we need some help to follow these guns, and they didn't ever send the help. And one person can't do this all by themselves. And that there was not cooperation with the authorities across the border, as best evidenced by ATF employees within our embassy in Mexico City, that when they learned about Fast and Furious and they were ATF employees and their brothers and sisters were involved in this operation, they didn't even know about it. So I think there's an extreme difference of tactics by one administration versus this administration.
But do you know if there were hand grenades involved in that?
I know, I have read. I'd need my staff to answer the question in detail for you, but that there were things that could be used to assemble hand grenades that cross the border.
Time for one more question. Yes.
TJ issued a statement yesterday trying to offer evidence there was no third gun found at the scene of Brian Terry's murder. At this point, do you believe there was a third gun?
Well, we know this, and first of all, I can't answer your question, and they ought to be able to tell us this. And why don't they tell us? You know, but we know the two guns that they did ballistic, you know, what do you call it?
Ballistic?
Lab testing, you know, that they numbered those guns 2 and 3. Well, if there could be a third gun that was number 1, but we need an answer to that. Now, you see, here's where you get back to something very basic, not just about your question, but about all these questions when the president or the attorney general says we're acting politically and we misinterpreted what he said on May the 3rd to the committee, that he knew about it a few weeks before. What do you expect the attorney general to read every memo that goes across his desk, even though 3 or 4 or 5 memos included something about Fast and Furious? Well, let's give him some benefit of the doubt. But the way to answer all these questions is to give us the documents that we are requesting, and the documents will speak for themselves, and the extent to which the attorney general ought to know something or didn't know it, it would speak for itself, and all these questions would be answered, and they could be answered tomorrow.
Senator Grassley, thank you very much. I know you need to get back up to the Hill. We appreciate your time. Thank you, Senator. And thank you all for joining us this morning.